The next thing I want to talk about when it comes to probate, the approach that my team and I take is number one, we help you identify whether or not there's going to be a will. Okay. And that's kind of the start of this. Is there a will? Now, remember, a will is a legal document that the probate court follows to transfer the assets. So if I have a will and I leave my assets to my children, and the will specifically lays out, I leave it to my children, then the probate court will take all those probate assets and they'll transfer them to my children. However, if I don't have a will, then the probate court will transfer the assets under what's called intestate succession. Now, intestate succession is a legal proceeding where the probate court designates certain individuals to be your heirs or next of kin. Typically, it goes as follows. If you have children, it would go to your children. If you don't have children, it would go to your parents. If your parents have predeceased you, it may go to your siblings. If your siblings are gone, then if they have children, it would go to them. And it's a big, complicated analysis that ends with what the courts call the sixth consanguinity, right? And so it's a big analysis. So whenever my team and I are in a situation where we have to identify who the heirs are pursuant to the intestate succession laws, we end up making a family tree. And in that family tree, we identify, children, parents, grandparents, aunts and uncles, cousins, so that we can figure out who's supposed to legally inherit. Again, if you have a will, the will designate who is supposed to legally receive your assets. In the event that you don't have a will, then those assets are determined pursuant to the intestate succession laws here in Ohio.